Ripple Labs and the Securities and Exchange Commissions have been fighting a contentious legal battle for a considerable amount of time. The stakes are quite high. The Securities and Exchange Commission (SEC) has presented a forceful response to Ripple's most recent court filing, which is the most current development in this matter. The Securities and Exchange Commission (SEC) submitted a new document to the United States District Court for the Southern District of New York on July 3, 2024. The purpose of this document was to challenge the company's reliance on a recent verdict from the case against Binance Holdings, which was limited to argue against harsh penalties in the company's current case. The purpose of the document was to provide a counter-argument to the company's argument. The SEC provides a response to Ripple's interpretation and application of the Binance order were subjected to heavy criticism in the file that was presented by the SEC and was prepared by Georgia Guerrero. The filing was submitted by the Exchange Commission. Guerrero makes the filing observation with regard to the company's reference to the decision made by Binance. The decision that this authority made on a motion to dismiss in the case of CV, Binance Holdings Ltd., is completely unrelated to the motion that is currently being considered about remedies. In his argument, Guerrero contends that the company's citation of the Binance ruling is not only erroneous but also unrelated to the matter at hand. According to additional reading, a lawyer who supports XRP believes that a ruling against Ripple will be handed down by the SEC very soon. Guerrero further stresses the mismatch in the firm's argument by pointing out that it highlights one remark in the almost 90 pages of the Binance verdict and tries to extrapolate from that broad observation about the effectiveness of the SEC's litigation strategy. This is an argument that Guerrero makes in order to accentuate the disconnect. Ripple's actions were not recklessly disobeying the law, which means that harsh consequences are not needed. This is the viewpoint that is being discussed. This serves as an illustration of how Guerrero emphasizes the disconnect in the argument that the company is making. In order to present a critique of this method, he says that this not only does not follow, but it also contradicts itself. In its complaint, the Securities and Exchange Commission (SEC) included an additional charge which stated that the corporation had omitted to include crucial components of the Binance. The finding that was reached in the Ripple case is comparable to the conclusion that the Binance court brought about when it rejected the reasonable notice defense. The Securities and Exchange Commission is said to make the following observation while quoting the ruling that was handed down by Binance. The fact that the defendants were said to have actual knowledge that the SEC could prosecute them was noteworthy. The SEC's view that the corporation had received adequate warning through legal advice regarding the sale of XRP is closely aligned with this statement, both of which are in close agreement with one another. Furthermore, after suffering a loss in court, the chief legal officer of Ripple has expressed his disapproval of the illegal actions taken by SEC under Gensler's direction, the U.S. Stocks and an Exchange Commission, as well as the members' past court rulings, which have consistently determined that Ripple was aware of the potential repercussions that their operations could have for stocks, are all examples of the factors that have been considered. In addition, the agency said in its response that, for the same reason that the case with Ripple was similar, the court in Binance confirmed that the cryptocurrency industry had been fully informed of the regulatory framework through the Dow notice that was published by the SEC in July for the year 2017. The stance presented by the fintech business regarding the dearth of regulatory clarity is directly addressed by this, with the emphasis being placed on the fact that the SEC had stated its regulatory intentions which Ripple should not have been shocked by. This particular point is particularly essential for the SEC's contention that it should apply more severe penalties of more than $2 billion, in contrast to Ripple's claim that the civil penalty should not be more than $10 million. Ripple maintains that the civil penalty should not exceed $10 million. There will be substantial ramifications for the cryptocurrency industry as a result of the current case, particularly with relation to the manner in which digital assets are governed and the enforcement measures that can be anticipated. In a recent statement, the Securities and Exchange Commission (SEC) highlighted its aim to regulate the cryptocurrency industry because of Judge Jackson's judgment involving Binance's BAMI coin. The current legal battle between Ripple and the SEC has been more serious in recent days. This is especially true after Judge Jackson's decision. The attempt by Ripple to incorporate the Binance issue into the action that is already being taken against Ripple has been received with criticism from the Securities and Exchange Commission. Ripple Labs has made significant progress in their legal battle, according to a report written by the Commission of the Securities and Exchange Commission. During the remedial stage of the complaint, the Securities and Exchange Commission sent in its answer today. In response to the Remedies brief, the Securities and Exchange Commission C contested Ripple's argument that the blockchain business behaved without recklessness and that there should be no widespread doubt surrounding the legal status of XRP. Ripple's assertion was made in response to the Remedies brief, in spite of the fact that the court had previously dismissed this defense of fair notice. This action was taken. An excerpt from the Securities and Exchange Commission's answer to Ripple's notice of supplemental power was released by defense attorney James Filon on an X post. The SEC responded to Ripple's notice of supplemental authority. The reasons presented by Ripple were not accepted by the regulatory organizations. An article titled SX versus the Relevance of Binance's Rulings is rejected by regulators. And first publication of an XRP case was made available on Coin Edition. Ripple is utilizing the Binance case in order to enhance its argument against the Securities and Exchange Commission. A notice of additional authority has just been submitted by Ripple, an enterprise blockchain company based in San Francisco, in response to a ruling in the litigation that was filed between the United States Securities and Exchange Commission C and Binance. The application that Binance filed with the United States District Court for the District of Columbia to dismiss allegations that sales of particular cryptocurrencies constituted sales of securities was partially granted on June 28th. Binance's move was presented in an effort to dismiss the allegations. In the case of the Securities and Exchange Commission versus Ripple Labs, the notice that Ripple received stated that the court had complied with the finding that was reached by the summary judge. The decision that the federal judge Amy Berman Jackson made about Binance included a particular reference to the ruling that was made on Ripple. She did this in order to adhere to the logic of Judge Torres, who distinguished between sales made on the secondary market and transactions made to institutions. Furthermore, the court has expressed its displeasure of the SEC's approach to industry regulation through litigation, claiming that it does not provide a sufficient amount of clarity to the relevant parties. According to Ripple, this remark provides credence to its position that the clear clarification of the legal status of a range of cryptocurrencies was an essential component of the ruling regarding the summary judgment. Ripple believes that this observation lends credibility to its contention. This regulatory uncertainty, according to the reasoning presented by the corporation, suggests that the company did not exhibit reckless contempt for the law with reference to its XRPs. There is still a dispute between Ripple and the Securities and Exchange Commission on the remedies that should be implemented. It has been requested by the SEC that Ripple pay fines and penalties totaling more than $2 billion. Coinbase is also challenging the SEC by utilizing the ruling that was made by Binance when it was established. Additionally, Coinbase is making use of the momentum that was produced as a result of the decision that Judge Amy Berman Jackson issued in the case of said Binance. To be more specific, the exchange made reference to her discovery that secondary sales of Binance's Binance Coin do not satisfy the requirements for securities transactions, as determined by the Howey test. In a letter, the attorneys representing Coinbase accused the Securities and Exchange Commission of participating in rulemaking without a consistent framework. They claimed that the SEC had made decisions at random. Additionally, they said that the Securities and Exchange Commission (SEC) has never properly explained its regulatory strategy, but that it is currently attempting to impose it on the market for digital assets through robust enforcement. Coinbase filed a complaint against the Securities and Exchange Commission and the Federal Deposit Trust Corporation on June 27th. The complaint was filed against both of these organizations. According to the exchange, both institutions should collaborate in order to prevent the cryptocurrency industry from entering the financial system. This is the central argument of the exchange, asserting that the agencies did not comply with the Freedom of Information Act,